Everybody, welcome back to another episode of Late Night Review. In today's review, we will be reviewing trial days 31, 32, 33, 34, and 35. So we're going to put them all together because there were a few days with just not much information, so we're going to get them all together right in this video. So let's get into it. Day 31 was Miss Beverly basically reading the charges to the jury and explaining about the different ways they are to find her guilty or not guilty and the items that must be met in order to be beyond a reasonable doubt in order to select that type of count. So she's charged with 3 counts. Count 1, murder in the second degree. Count 2, manslaughter while operating a motor vehicle under the influence. Count 3, leaving the scene of an accident resulting in death. So for a second degree murder, 1, defendant caused the death. 2, intended to kill or cause bodily harm where death would result. And 3, if the act was caused with knowledge, knowing it could cause the death. Manslaughter while under the influence of liquor while operating a vehicle. So 1 would be operating a vehicle while intoxicated, and 2, operating a vehicle on a public way. Involuntary manslaughter would then include leaving the scene of the accident. Now, those can probably be broken down a little clearer and better. So the best way I could describe it would be count 1, murder in the second degree, count 2, manslaughter while operating a motor vehicle under the influence, and count 3, leaving the scene of the accident resulting in death. And with that, the jury was sent to deliberate, and then they came back, and that was the end of the day because they did not come back with a verdict that day, and that was the end of day 31. So we're at day 32 now. The defense asked for a charge in the verbiage of the guilty slip to be changed so that way it was a little clearer. That's kind of all we saw in court that day. At one point near the end of the day, the jury did come back because they wanted to go home for the day, and so that they came back with no verdict on that day either, and that was day 32. All day. So now that we're at day 33, we went all day again with no verdict. We're at day 34 now, and now you're probably seeing why I compiled all of these days together in one video. Now on day 34, the jury sent a letter to Judge Canoni to tell her that they were unable to come to a unanimous verdict. Judge Beverly went ahead and asked Lally how he felt about that, and Lally said he doesn't believe that the jury has had sufficient time to come to their verdict since it's only been a few days, and that the note says that they were unable, not that they couldn't come to a unanimous verdict. So he believes that they needed more time. Mr. Yannetti said he disagrees with Mr. Lally and feels that they have had enough time to deliberate, and that the word exhausted is the word that should be focused on, and that they have used all their manner of compromise and persuasion with each other and are at an impasse. So he believes that, that the focus shouldn't be on the word unable to, and the focus should be on exhausted. I mean, if they are sending this letter after several days of deliberation and they're saying, we've exhausted this, like clearly they have been in there fighting with each other about this for a while now and still have not come to an agreement. And in this case, Judge Beverly gets to make the decision whether she's going to go ahead and accept that note from the jury or send them back to deliberate longer. And Judge Beverly believes that they actually haven't had enough time because of a shortened day and an appointment the next day. This day, it's only 12 o'clock and they've already sent this letter to say that they're at an impasse. And so she believes that since they've only been deliberating today for 3 hours, that they need to go ahead and go back. And so she sent them back to continue their deliberations, and that continued until the end of the day, and they came back and said, we're ready to go home at the end of the day. So they went ahead and went home. We got no verdict again for day 34. And so they will continue to deliberate on Monday. So they'll have the weekend to relax and try to get everything out of their head. So that way they come back fresh on Monday. So let's go to day 35. Welcome to day 35. For trial day 35, we're going to start out with a couple videos. So a couple clips, so let's take a look at those.
First about doing thorough deliberations. I'm sorry, I didn't hear the last one.
I'd like to hear from the Commonwealth first about your view on whether the jury has conducted due and thorough deliberations.
Your Honor, while I understand that they have been at this for a while, I would submit that they have not, and I would ask the court not to make such a finding. Reasons for that, Your Honor, this jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified before them. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
Ms. Tianetti?
Our view is that it's time for Tuey-Rodriguez. They've come back now twice, indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. The previous message said that they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means, and it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tuey-Rodriguez is for. We asked the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due and thorough deliberation. So I'm going to give Tuey-Rodriguez. So, jurors, I am in receipt of your note. Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out.
Now that you saw that, the jury had come back, being a Monday now, and they still said they're at an impasse with this. Judge Beverly said she is going to initiate a Tuey-Rodriguez instruction. What that instruction is, it's like a last-ditch effort to get a jury to get out of being deadlocked. The best way I know to describe it is it's like putting a gun to the jury's head and saying, listen, you're going to listen to the other jurors very carefully and with an open mind. And then you're going to come to a conclusion after that, because no future trial is going to give you any more information, or any other jury any more information that you're going to have right now. So with that knowledge, know that you need to go back and with the information you have been given in this trial and listen to your fellow jurors carefully with an open mind. That's basically what you're doing at this point.
Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Thank you. We'll see you then.
So that's that. It was declared a mistrial. And since I did this review so far out, we now just found out that the Commonwealth is recharging Karen. So this is supposed to go, yes, that's what I said. This is supposed to go back to court again in January, I believe. So I don't know if I can sit through another whole trial on this to give a review for day-by-day coverage. I may do a summary, just an entire trial summary. But that's where I sit right now. It has taken so much time to create all these videos, and I am so grateful to everybody who watched and commented on my videos. I enjoyed 99% of the comments, even the ones that were a little rude. I still, I'm grateful that they took the time to watch the video.
This is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit.
Alan, you're going to stay on?
Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas, like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
And with that, we ended this whole trial with a deadlock. I'm really curious to know what juror thought that Karen should be convicted, and what did they base that feeling off of. If it was solely on the comment of I hit him, I'm just curious on why they thought that comment actually took place. Because as we saw during that trial, nowhere at any point did any of those professionals ever write or document that she said, I hit him. It didn't come until later. So I'm really curious to know who thought she was guilty. The Commonwealth is going to continue with their pursuit of prosecuting Karen. And so that's going to come back up in January of 2025. Let's just say even in the next trial that let's just think what they felt they should remove. I think they might remove maybe Trooper Proctor's text messages. They may remove that evidence out of the trial. As you probably know, lots of evidence is allowed into trial and lots of evidence is not allowed into trial. Honestly, they could eliminate a lot of those people's testimony, and solely based off of the experts' opinions in this case, I would not find her guilty based off of that. The fact that he doesn't have any damage to the lower half of his body is a big problem for me, and I don't care at this point who said what, who did what. Even if Michael Proctor had said none of that stuff through all his text messages, even if someone came out and said I saw her hit him, I would still be like, okay, where is the evidence on John's body to prove that he really did get hit? And right now, the expert testimony, the accident reconstructionist testimony, just totally, in my mind, it sealed the deal for me. Like, I waited just every day over and over again for Lally to give us information to prove that Karen killed him. And it just never came. Like, I would love to have justice for Mr. O'Keefe, but what the prosecution provided in this case was just not sufficient enough to even bring up a guilty on a manslaughter charge. Like, I just don't see it. Like, nothing pointed that direction beyond a reasonable doubt. I think another big sign for me pointing to Karen's innocence too is like when Karen spotted him that morning, she's the one that ran over there, grabbed him, and started doing mouth to mouth to try to save his life. Like, even though he had blood all over his face, like, she's putting her mouth on this dead man's body, trying to bring him back to life. And prior to that, before she even knew he was dead, like, she called him over 50 times. Like, who kills someone intentionally and then calls him 50 times, slowly getting angrier as the night, as it progresses, because he's not answering her calls or returning her calls or text messages. Like, clearly, this is a person who had no idea that the individual was dead. And then don't you think she would also be giving like kind messages, not like yelling at him and calling him an effing pervert and all this other stuff? Like, that just contradicts somebody who's angry at the person and wanting to kill them. Like, those are two things that just don't jive in my world. Maybe they jive in yours, but here in reality, they don't jive. And so even if we were to exclude all of that evidence, The expert testimony on its own is what solidified my decision that I think Karen should be found innocent. But with that, I want to thank all of you so much who took the time to leave messages, ask me questions, answer questions that I had. I appreciate every single one of your messages. But I will be reviewing another case in the future. So I thank you so much for all your views, and we'll talk to you another time. Have a good night. Bye.